Hello and welcome to the 5th episode of the Joshlin Smith Trial Wrap. Let's take a look at what unfolded in court and how Judge Nathan Erasmus arrived at his ruling on the admissibility of statements made by Jacquen, Appollis and Steveno van Rhyn, now officially admitted as evidence in the main trial. Western Cape High Court Judge Nathan Erasmus has ruled on the police obtained statements from both Jacquen, Appollis and Steveno van Rhyn on the 4th and 5th of March 2024 will be allowed as evidence in the main criminal trial. The two, along with Joshlin Smith's mother, Kelly Smith, face serious charges of kidnapping and human trafficking linked to Joshlin's mysterious disappearance from her Middelpos home in February last year. This decision marks a pivotal juncture in the case, with the main trial expected to resume next week. 7 weeks into the Western Cape High Court sitting at the White City Multipurpose Centre in Saldanha, designated as a high court to give the community access to proceedings, the case of missing then 6-year-old Joshlin Smith reached a pivotal moment. Halfway through the 3rd week of the main criminal trial, proceedings paused for a trial within a trial. At issue, allegations of torture and coercion against the police during interviews with accused Jacquen, Appollis and Steveno van Rhyn in March. After nearly 3 weeks of heated arguments and testimony, a key development unfolded on Thursday. The Western Cape High Court ruled that statements made by Appollis and van Rhyn to police would be admissible, marking a significant turning point for the main criminal trial.
It is admissible evidence in the main trial and can be used against the accused. You would have noted that I've not referred to these statements either as confessions or as admissions. I do that deliberately, as I do not want to create the impression that I've prejudged the issue. There might be a lot of water under the bridge already, but there may be more storms coming. I don't know what they are. Customarily, one does not give reasons for the ruling, as it is an interlocutory ruling that may be revisited at a later stage in the trial. This is not the end of the case.
Before the ruling, the court became a battleground during closing arguments. Witnesses included police officers, 2 doctors from Vredenburg Provincial Hospital, and a civilian for the defense. Defense lawyers focused on 3 points: whether rights were read, allegations of torture and coercion, and the overall admissibility of statements.
My submission to this court is, the question is there a reasonable possibility that accused 1 had been injured and assaulted? He was crippled, that could have been seen on the video of the confession. His eye was definitely swollen, and it was pointed out that his right hand was swollen, and I leave it to the decision of the court, and submit that accused 1's rights were clearly violated, irrespective of his credibility, and that the admissions, what he made, should not be admissible.
Still in a bid to sway the decision of the court, Steveno van Rhyn's lawyer challenged the admissibility of her client's statement.
We submit that it is not an unequivocal acknowledgement of guilt. When it was taken, he was not in sober senses and sound mind. It was taken against his will, as he was unduly influenced. The state has underplayed the effect of this unrelenting interrogation of accused number 2 the psychological pressure he must have been subjected to.
Police officers denied all allegations of using force. The state maintained it met the burden of proof.
Whenever an accused person disavows the contents of a statement made, that this court must have sight of that document. So the prosecution, therefore, is entitled to cross-examine, which is exactly what has transpired in this instance. So on both those authorities, this court acted cautiously and correctly on the law. The state's position is that it has discharged that onus when it led evidence of Captain Lombard and Sergeant Fortuin. Those witnesses' evidence were not shaken under cross-examination. They made credible witnesses. The more important part of the state's evidence, my lord, was the independent evidence of the doctors. And it was the doctors' evidence that the allegations, as I put to them and demonstrated to them, was highly improbable. In fact, their evidence was that they would have expected to see fractures, far more severe injuries, as opposed to what they saw.
Building up to a tense close of the week after hours of court proceedings, both the prosecution and defense spent hours battling it out. Jacquen and Steveno took to the witness stand to give their evidence in chief and for the state to test and poke holes in their testimonies. Appollis testified that a male officer instructed him to say that Kelly ordered him and Steveno van Rhyn to take missing Joshlin to an individual known to the court as Makalima for 20,000 rand. Under intense cross-examination by the state at the Western Cape High Court, Appollis claimed he was coached by an unknown police officer to implicate his friend and co-accused, Steveno van Rhyn.
Do I understand you correctly? So when you went to sit down there next to him, you didn't have a story in your head. You just had the part that the police told you what to say.
That's correct, yeah. Correct, my lord.
Why did you find it necessary to add in all that fine detail on the fly?
Vir my was gesê gewees dat ons die kind gaan verkoop het en dat Kelly vir my gestuur het en vir Steveno om die kind tot by Makalima te neem en ek moet dit laat soos 'n storie laat klink het.
Of het alles dit vertel omdat dit die waarheid is.
Dat is nie die waarheid hier.
That's not the truth, my lord.
The fact that there's such specific, intricate details
Die
in this
feit
document.
dat dat bevattend in die verklaring is, dat sulke intrige details.
All of which comes from you.
Ek verstaan so.
I understand.
The argument before this court is going to be, it is the truth.
This week, under cross-examination, he made an about turn, admitting to misleading the court, but with reason, he said.
Want ek was bang en ek moet net so 'n regte storie laat lyk.
Because I was afraid, I wanted to make it sound as a real story.
Is the prosecutor right when she tells you that you deliberately lied to the court on Friday?
Ek het nie met bedoeling die hof gelieg, Here.
Previously, during his evidence in chief, Appollis and his lawyer painstakingly went through his contested statement line by line, clarifying which parts were true and which were allegedly dictated by police. With his admission, Judge Erasmus explored avenues in the about turn from Appollis.
You said you've left out one line. What is the one line you've left?
Die part waar ek en Kelly 'n discussie het oor.
So what went wrong?
Wat het toe verkeerd gegaan, meneer?
Ek is nie seker hier.
I'm not sure, my lord.
Just one moment, Mr. Rhyn. Did it make a difference that Ms. Smith was not in court on Friday?
Juffrou Smith se afwesigheid by die hof, het enige verskil gemaak?
Nee, Rawa.
No, my lord.
With Appollis preparing the way, next, Van Rhyn testified, recounting how police allegedly tortured him during interrogation.
Toe ek sien maar Boeta hang daar so.
When I saw Buddha is hanging there,
Toe soet ek vir meneer Fortuin. En ek sê meneer, ek praat nie waar nie.
I begged Mr. Fortuin and said that, but sir, I'm telling the truth.
Vir my het hulle gesê my tyd is om.
and I was told that my time is over.
En halve Boeta af.
They took Buddha down,
En hulle sê vir my, ek moet my sweater uittrek,
they told me that I must take off my t-shirt,
en my tekkies.
my tackies,
Toe sê hulle vir my, ek moet op my rug lê.
and they said that I must lay on my back,
Dan moet ek my twee bene so na my bors toe bring.
and they said that I must bring my 2 legs to my chest.
Can continue?
Come forward.
Dan moet ek my twee hande so oor my bene dinges.
I must take my 2 hands and put it in front my things,
Toe boei hulle my vas.
and they handcuffs me,
Met druk hulle 'n pyp tussen my onder my knieë deur.
and they put a pipe, my lord, the witness shows, they put a pipe under my knees, the witness shows.
En ek is opgelig
I was lifted, my lord.
en op 2 stoele gesit.
I was placed on 2 chairs.
The state, however, rejected these claims, arguing that the accused's version of events is not only inconsistent, but also physically implausible.
It's impossible
Dit is onmoontlik
for you to have spun around like
dat
that.
u Polmakisi so gemaak het in daardie posisie.
If we consider the demonstration that we just saw and the
Indien-
limited space.
Indien ons na die demonstrering kyk wat u sopas getoon het in daardie beperkte ruimte,
Ek was hier heen en weer mos in die ronde geswaai nie.
but daar was nog span around,
Even
selfs
your amended version of just swinging
u gewysigde weergawe van net swaaiery,
even that
selfs daardie
would be impossible
sal onmoontlik wees.
in that limited space as demonstrated. The injuries that you had
Die beserings wat u opgedoen het,
is not at all reconcilable with your version.
dit is glad nie versoenbaar met u weergawe nie.
And that's not my opinion.
En dit is
That's,
nie my opinie nie.
that's what the doctors testify.
Dit is wat die mediese dokters oorgetuig het.
Under grueling cross-examination by the state, Judge Erasmus reminded Van Rhyn how crucial his testimony was and to seek clarity when unsure.
Mr. Van Rhyn, just listen to the question. She's going to try and keep it short. And if you don't understand it, then you just say, I'm not following. I am very conscious of the fact of your level of education. It doesn't mean that you're not intelligent enough. But I don't want you to trip up because of the setting in the court and or that we're using long sentences, big words, because your life's on the line here. Literally, your life is on the line.
Next week, the state will advise the court on how it plans to proceed.
So now I'm explaining it to the three of you as well. Because you might be expected on Tuesday, after you know by tomorrow afternoon how the wind blows on these statements, to consider what instructions you're giving your legal representatives, if there are any witnesses, because we might be on the defense case still in next week. It might be.
That concludes the proceedings for this week. Thank you for tuning in.